Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. All right, we have most people in from the waiting room. Thank you for joining us this afternoon. I'm happy to get us started. My name is Katie Jones with ADR Services, Inc., and it is my pleasure today to introduce our program, Probate Mediation, Mediation of Trust and Estate Disputes, focusing on the mediation session. This is part 2 of a 2-part Trust and Estate Mediation series. Part 1 focused on preparation was a couple of weeks ago. If you missed that, the recording of the program will be posted on our YouTube channel in the next couple of weeks, as will the recording of today's program. So you'll have a nice little packet of this 2-part series, all available for self-study MCLE credit on our YouTube channel within the month. So without any further ado, it is my pleasure to introduce our panel today and our panelists. So again, this program is entitled Mediating Trust and Estate Disputes, focused on the mediation session. Introducing our panelists in the order in which they will be speaking today. First, we have Judge Barbara Johnson. Judge Johnson retired from the Los Angeles Superior Court in 2020 after 27 years on the bench. She enjoyed a distinguished judicial career as a trial judge with assignments in probate, the appellate division, and the criminal department. For the last several years of her judicial career, Judge Johnson served in a probate court assignment, drawing upon her prior experience as a probate lawyer to oversee a wide range of probate-related matters. And prior to her appointment to the bench, Judge Johnson began her legal career as a sole practitioner, handling probate, family law, landlord-tenant, and criminal matters. She then joined the city of Inglewood as a deputy city attorney and then later as assistant city attorney. And then she remained there until her appointment to the bench in 1993. So she is an expert here in the trust and estate matters that we'll be discussing today. Thank you for joining us, Judge Johnson. Next, we have Judge Marshall Whitley. Judge Whitley practiced tax and estate planning before his appointment to the Alameda County Court in 1993 as well. During his last 10 years on the bench and before retiring in 2013, he served first as the supervising probate judge and then handled all complex and long-cause probate trials. He presided over hundreds of cases involving trust, probate, real estate, accounting, and tax issues. Judge Whitley also chaired the California Judicial Council's Probate Education and Research Committee and was appointed to the Council's Probate and Mental Health Advisory Committee. For many years, he also taught law school courses on wills and trusts, probate procedures, and mediating trust and estate disputes. His contributions have been recognized by the California Lawyer Association as one of the small and select group who has received both the prestigious V. Judson Klein Award and Joanne M. Garvey Lifetime Achievement Honor. Since joining ADR Services, Inc. 11 years ago, his depth of knowledge in probate, tax, and accounting, coupled with his excellent interpersonal skills, have really enabled Judge Whitley to mediate successfully a wide variety of cases with high emotional content, as well as those involving technical and complex factual and legal issues. Thanks so much for lending your expertise to us today, Judge Whitley. And last but certainly not least, we have Bruce Ross speaking on our panel with us today. A prominent authority on trust, estate, probate, and conservatorship law, Bruce brings over 40 years of experience to resolving estate, trust, and financial elder abuse disputes at trial and through settlement and mediation. He's put these skills to work in his mediation practice for over 20 years, and he's regarded as a highly effective mediator by his peers and successfully combines facilitative and evaluative approaches in his work. He's really calculated to answer the specific needs of the parties who entrust their mediation to him. The author of authoritative Rudder Group Practice Guide, Probate 1986 through 2011, and Goodness, you still work with Thomson Reuters as a co-author, right? So he is the co-author of the Leading Practice Guide, updating it annually since 2012. And with his background as a certified specialist in estate planning, probate, and trust law, Bruce is well equipped to deal with almost any disputes involving these practice areas. So we really have an expert panel here to lead us off today. Without any further ado, I will hand it over to Judge Johnson, who will be starting us off for this afternoon's program.
Thank you, Katie, and good afternoon to everyone. I'm putting my timer on. We have a lot to complete in the next hour or so, and my time is limited. So this is an overview. I'm sure some of you have heard the last presentation before this one. This is segment number 2. And the first thing is we're going to talk about is pre-mediation, which includes number 1, the exchange of the pre-mediation briefs. Why? I can't think of one mediator does not require a mediator brief. 1, because it facilitates communication. Because there are many times where the attorneys haven't even spoken to each other, let alone try to exchange any briefs. It's unfathomable, but it's true that sometimes attorneys put out a lot of emails, texts, and paper, but no actual conversations. And so that's why I require specifically a pre-mediation brief, because they facilitate, as we say in the first communication. The second is because it keeps the information flowing. The pre-mediation brief should be succinct. It should include dispositive facts, if there are any. It should not include any quips about the opposing side or ill feelings that can be taken an issue right off the bat, and so the mediation is sure to fail then. It should be transparent, it should be candid, and there shouldn't be any hiding of the ball in the mediation brief. The third thing is that it focuses the issue. The mediation brief focuses the issue. It should include the must-haves. It should include any negotiable issues, and things like who will be the trustee. That's a big question, but sometimes the brief is not inclusive of that, and sometimes that is the issue that has to be decided. And so this brief that we're talking about should include those things. Focus the issues down to the things that can be settled in mediation and why you're actually there for mediation, not to take swipes at either side of the litigation bar. And lastly, it should emphasize the honesty. It should emphasize honesty during the mediator calls. What? Mediator calls? Yes, most of us require a mediator call before the mediation begins. And why? To see if there are any problems that can be solved before we actually get to the mediation, to see if there are any ill feelings that can be smoothed over, to see if there's any client expectations that we should know about ahead of the mediation process. And hopefully the attorneys for each side have discussed with their client what their expectations are and what should happen during the mediation process. And so that's why we exchange the mediation briefs exchange is so important before we even start the mediation process. Next slide, please. The next thing that's important in a mediation is the availability of crucial documents during mediation. You'd be surprised that a lot of times when we get to mediation, even if we've had a mediation brief, we don't know, the mediator certainly doesn't know what we're there for. We've talked maybe an hour, we've gone through over things, and then to come to find out that there are no property valuation reports. Well, if property distribution is important in deciding this mediation, why don't we have a current report? Sure, we can look up on some site to find out what the value is, but really we should have a written report. And so we should start off the probation or probate with a report of this value of the estate. There should be updated bank statements and newly found assets that we didn't know about ahead of time. Those should be already ready to be discussed at the time of the mediation. We should know whether or not there's any pending motions. Do we have enough information to make this mediation successful? And a lot of times we just don't have enough information to even to have a proper discussion because there's so much that we don't know. Have the expenses been paid to date? How much attorney's fees are now owing by the time we get to this mediation process? Are there liquid assets that can be exchanged for real property assets? Or can they even be liquidated? The real property, can it be liquidated? Have there been waiver of fees? Is waiver of fees possible to get to whether or not, attorney's fees, to get to whether or not the case can be settled or mediated? Those are some of the things that we need to know. Is there a compromise available? Are we out of time for a compromise? Do we get to 4 o'clock, say, if it's an all-day mediation? Do we get to 4 o'clock to find out that we might have a compromise, but it's going to take another 2 or 3 hours or 4 hours, even another mediation, we'll talk about that later, to settle the case, to come to a agreeable decision. And my whole thing about having available crucial documents available is that helps the process to go forward if we know exactly what we're dealing with. And sometimes we might even have to extend the mediation because we don't have enough information. And so we have to decide whether or not, is there, for instance, a condition? Can we have a condition that we can extend the release of the lien, or have the lien voided at that time so that we can proceed with the mediation process? So the main point about this is that we have to have the most crucial of documents ready during the mediation, and not have your client say, yeah, I did spend that money. That statement is here somewhere, or if they don't have it, I can call my bank right now and I'm sure they'll send it over to me in 10 minutes. Well, that never happens. So having the most crucial information available during the mediation speeds the process, makes it less complicated, and allows for an open discussion of what is what, how much is the estate is worth, how many people are involved, is there a lien, are there alternatives to selling the case? Right. The next slide, I know I'm going quickly, but I have, again, there's 3 of us and we want to answer some questions at the end. And so you can put the questions in the chat. This point that we've had discussion about amongst us is the handling the proper or self-represented litigant in mediation. And this issue is arising more and more because of the Breslin case, which is Breslin versus Breslin 62 Calab 5801 in 2021. And just in a nutshell, Uncle Don died without a spouse or children. He had some nieces and nephews, and he wanted 24 charities to partake of his estate. The court said, okay, to settle all this out, you guys go and to mediation and work this out. And when you do, everybody's supposed to get notes. So one of the charities, only 5 charities out of the 24 participated. One of the charities wrote notes, or notice, that tells them that the mediation, that they're invited to a mediation, that the mediation would result in, or could result in, the settlement of the matter that is the subject of the reference case. And any or all persons interested, all persons that are interested or have interest therein should attend. and that the settlement of the matter could result and may result in an agreement for the distribution of assets of the above referenced trust. This is a trust case. The most important thing to me in Russell was that the warning, this is the warning, non-participating persons or parties who receive notice of the date, time, and place of the mediation may be bound by the terms of any agreement reached at mediation without further action by the court or further hearings. So this notice went out, the notice was continued several times. Finally, they had it. The 5 charities, along with the heirs, came to an agreement, took it to court. The court, then one of the charities petitioned the court to have the agreement approved for settlement. At that time, about 10 other of the charities who did not participate at the case objected. Well, it went to appeal. The appellate court says the non-participants were out of luck. The court gave you, and the court's order was for mediation. You got notice of the mediation. You knew what could happen if you did not attend the mediation. And so their agreement stood. So what does it have to do with pro-pers? A lot of times in our mediations, non-participating mediators, non-participating litigants who show up at the mediation says, look, I got this notice, I'm here, I don't really know what's going on. I'm supposed to get something, I'm entitled to something. I'm not represented here by an attorney. I don't have any, and they don't have a duty to retain an attorney. They probably don't have any money to retain an attorney. They don't have a duty to agree to anything. I'm here, and they can appear by Zoom. So they don't have to appear in person even. And they know just enough to make you prolong the trial. They know just enough to get you the trial lengthened. So the question is, should the attorneys explain to the non-represented purported heir or interested party what's going on, or should that be the mediator's role? I think that as many that can explain to help the pro-per agree, the better. Not to force the person, as long as they are honest and candid. You can't misinform them. But as much as they know about the case, that happens, because they might be aligned with some other represented party. So you might want to put them in that Zoom room if there's a Zoom room, or they can be by themselves. I had one where there were 6 children. The children were divided into 3 groups, and then this other person who was not represented, wasn't really a part of the group. The attorney had to come in, or wanted to come in, and I asked the person, do you want to speak to an attorney? I've told you as much as I know about the case, but if you want to speak to other attorneys that may be aligned with your interests, you're welcome to do so. And so it's a good idea to have those persons understand what's going on, such that the proceedings will not be prolonged. And so I'm sure Bruce and Judge Whitley has, I mean, we could go a whole hour just on Breslin alone, so we can't do that today, but there are many reasons why and why not a pro-per in a mediation under Breslin who's just there because they don't want to lose out, which is a smart thing to do, how they should be represented and what should happen at that mediation process. At this particular one, I took the position, he's here, he should know everything that he knows. If he then wants to hire an attorney, oh well, he has that right to hire an attorney. And it's better to do it now than later on when he objects, and then the attorneys who have spent that much money to get to mediation in the first place now is has to spend more money to handle that pro-per's argument and issue and interest. As I said, that could go on a while, but just keep that in mind when we're talking about a mediation with non-represented litigants. And then the last case, I'm at my 14 minutes, guys. I can see that in complex cases, we're talking about mediation within a mediation. If nothing else in a mediation process, you should have a proposal of what you think the settlement should say. And if you see that it's not, if I see that there is an impasse, and I know the impasse early on, then we are now talking about what can we do? What can we agree on? What's one thing that can we agree on? Can we agree on who the trustee will be, at least? If there are warring persons about who should be the trustee, can we at least agree on that? Is it possible for them to be co-trustees? Can we agree that that this part of the settlement will help us go on to another part? If we can agree on one thing, maybe that would help us in another particular issue of the case. As I stated earlier, where there is many parts to a mediation, or when there just isn't enough information, I'll say, look, we've spent 4 hours on this. This particular issue is very important. We don't have the information. We can stop at 4 hours, continue it later after you get the major information that you need, and continue the mediation for the rest of the hours that you have paid our services for. So is a second mediation after initial session viable or even palatable? Maybe people are saying, I'm just done. But if we can negotiate with portions of the varying parties, especially if there's more than two parties. Usually there are more than two parties involved or two sides involved. Then we can manage our time and manage our billing in complex cases. So that's what we're talking about when we're talking about mediation within a mediation. What can we do to get the mediation moving toward its resolution by deciding at least one issue? Thank you. I'll stop there and turn it over to our distinguished Bruce Ross, who is our expert on this subjects. Thank you.
All right. Well, I'm gonna jump in just before Bruce does, and talk about my topic, and I'll turn it over to Bruce after that. And I appreciate it.
Oh, thank you. I'm sorry, Marsha.
Thank you, Judge Johnson. Appreciate it. My topic, as you can see, is entitled "The Art of Negotiating Trust and Estates Disputes." I am going to jump right in on this and dare to say that between the introduction phase of a mediation, where the mediator comes into the room and introduces themselves, and counsel and the client take the opportunity to educate the mediator, and the client has the opportunity to tell their story. In between that stage of the mediation session and the end of the mediation session, when there is a settlement and the settlement agreement is being drafted, finalized, and executed, that very important middle stage, that second stage of the negotiation, is what I want to talk about. And I want to give you my perspectives based on my experience on that negotiation stage. This is a very deep subject, and because of the time involved here, I only have a limited amount of time, so I'm going to do sort of a flyover. As you can see, the first part of the art of negotiating is preparation. And so I'd like to flip to that slide. So this preparation step is very important in terms of the negotiation. So this is what happens before you actually get into your negotiation. What we're doing during this step is we're managing expectations. And we're talking about managing certainly the expectations of the client, but also expectations of counsel. The first 4 bullet points that you see under managing expectations I could summarize that as adapting a negotiator's mindset, because that's what has to happen at this point. the party and counsel have either left their litigation and come into mediation, or it's a pre-litigation. But in any event, we're not talking about a party to litigation. The client is no longer a petitioner or a respondent. The lawyer is no longer counsel for petitioner or respondent. We're now talking about negotiator and counsel for negotiator in a mediation. So we're in a different setting. And so the pleadings need to sort of be pushed to the side with all of the allegations and claims that are set forth in the pleadings. We certainly keep them in mind, but we sort of push them aside. What we do sort of bring front and center a little bit, because we want to focus on that, are the negatives about the alternative. In other words, litigation. The litigation costs and expenses, the litigation delay, and certainly the uncertainties of litigation. In fact, studies show that plaintiffs' counsel are only 65% of the time correct in terms of determining or guessing about what the result of the litigation is going to be. And defendants' counsel are even right fewer times, and that is 45%. So clients need to understand that while their counsel is there and doing a great job, it's what the result of their litigation is going to be is difficult to pin down, and it's uncertain. So clients need to understand that litigation, while an alternative, is not the best alternative, that in fact they're in a mediation, which is their best alternative. So they need to put on their negotiator's cap. The counsel for the client needs to put on their negotiator's cap, and we need to view ourselves as negotiators rather than parties in litigation. The negotiators, of course, the clients certainly understand that they're in a position with respect to the other negotiators, much like sellers and buyers are, in that they don't see the result the same way. They have sort of a differing and competing results. And that is what we're here for. We're here to sort of move toward each other in the negotiation so that we can bridge whatever gap there may be in our expectations. Counsel also need to understand that there's this thing called a halo effect that they come into the mediation with. In other words, they come into the mediation and it's their clients basically are following their lead in the mediation. If a lawyer gives a positive response during the course of a negotiation or during the mediation session, the client will have a positive feeling about it. If a lawyer gives a negative response to a communication or starts to denigrate or say something negative about the other side, they're not here in good faith, they're wasting our time, then the client is going to have that, generally speaking, have that same reaction. So the counsel in a mediation has to sort of monitor and be cognizant of the effect that they're having on their client by their actions and reactions during the mediation session. And because what we're trying to do, what the mediator certainly is trying to do, is to get the genuine reaction of the negotiator to a communication that is being made to them, so that we can then know how to help move the negotiation forward. The half empty glass, the half full glass, that's a pretty straightforward thing in that certainly during litigation, you're focused on half full, you're going forward because you want to win. In mediation, it's different. Negotiators need to take an objective perspective as much as they possibly can. And by an objective perspective, what I'm including there is not just the half full side, the strength of their arguments in case, but also the weaknesses, because that's what the opposite negotiators are focused on, are those weaknesses. And while we negotiate from strength, we also negotiate with the weaknesses in mind, because otherwise we won't be able to move toward one another. And that's the object of mediation, is to move toward one another. The next couple of bullet points focus more on setting goals in the preparation phase. In other words, counsel and the client need to have a good heart-to-heart talk prior to the mediation about what their goal is, what they want as a result of the mediation, what settlement goal they have. But they need to have a discussion even beyond that. And that is, what if we don't get there? What if we don't get what we want during the mediation? Can we then continue on further to negotiate, perhaps to concede or more? And how far can we go, discounting and taking into consideration, the risks that may be avoided by settling rather than litigating? So taking all that into consideration, the client and the counsel and the lawyer are setting what is their reservation point. In other words, we will go that far if necessary, but not any farther. So the negotiators, all come into the mediation, hopefully, with their reservation points. They know those. They generally don't share them with the mediator, certainly right up front. But those reservation points rarely overlap. There's usually a gap between them. And that gap between those reservation points is generally what I call, in some mediators called, the red zone. And that red zone is the zone within which a resolution can occur and is likely to occur. The next to the last bullet point is what I call how the negotiator should act. In other words, during the session. In other words, the negotiator has come into this because of the conflict and the dispute. Conflict and dispute is all about pointing fingers and blaming. It's all about what has happened in the past, or what did not happen and should have happened in the past. Well, during the mediation session and the negotiations, we certainly want to hear about that, but we want to leave that behind at some point and talk about the present and the future. The present is, how do we reach an agreement? And what is that agreement going to leave us with in the future? Are we going to be satisfied with that? Certainly, any of these managing expectation issues that come up, or that the lawyer knows about, should be brought to the attention of the mediator in the pre-mediation meeting the lawyer has with the mediator. All right, so we've done the preparation. Now we want to move to the actual negotiation, which is the next slide. In other words, the negotiation, also known as the dance. So the first 4 bullet points there focus on what I consider to be getting the matter started, getting the negotiation started. The opening offer, who, what, when, who's going to make the opening offer? Traditionally, of course, it's the plaintiff who makes the opening offer in a mediation. Unless there have been some discussions or settlement offers made before the mediation, and then we try to pick up with where those might have left off and put some offers on the table based on that. And as you know, we don't always have cases where we've got a plaintiff and a defendant. We have sometimes, competing petitions. We have sometimes petitions that are filed by fiduciaries who just tee up an issue. And we have other parties who are really litigating the issue, who are responding to that petition, for instance, for instructions or whatever. So it's not always clear who should make that first offer when it comes to our kinds of cases. Certainly, if there's someone who volunteers and wants to do it, all the best. And in fact, sometimes it's a good idea. You talk with your mediator about this as to whether or not to set the stage. You be the one to make that first offer so you can start it off on a foot that you would like to start it off on. But that's something you discuss with your mediator. If no one wants to get this thing started, then what I do is I look around because of the types of cases we have. I look around to see if there is a neutral involved in the mediation, such as a court-appointed guardian ad litem, in a conservatorship matter or a matter involving, a minor. Does this court-appointed guardian ad litem, is that person willing to put an offer on the table for everyone to consider and negotiate? Or a fiduciary, if they're willing to do that. Often fiduciaries who are there in the neutral capacity don't want to do it because they want to remain neutral. But if they do and they feel comfortable with it, then they can do it. If all else fails, basically, what I do is I'll go around from room to room. I'll collect the terms that appear to be the terms that are the negotiable terms, and I will put them in a summary on the table, a sheet of terms for each party to kind of consider. If it's a complex matter with a lot of terms, I'll put it in writing and I'll take it around to each room. I'll indicate I have put this together from my discussions of everyone in the room, and everyone in the mediation session. And if it's something simple, I'll do it verbally. But in any event, that usually gets the ball rolling. So in any event, we're going to get these offers on the table. Well, what should be in the offer? Well, this gets really deep, and we certainly don't have time to talk about that. But suffice it to say that what mediators like is for the first offer to be what's considered a credible offer. And by credible offer, what's meant is that the party receiving that offer looks at it and says, oh, okay, I'm certainly not agreeable. This is not agreeable, but it looks like they're making a step in my direction. So it looks like they're here to negotiate in good faith. So in other words, you've sort of changed from what you might have said before the mediation and what your demands were as an offeror, and you've sort of and you've moved in the direction of where you believe your opposing negotiator is going to be, and you show that in that first offer. It doesn't have to be a significant move, but just a move that makes the other side go, oh, okay, that's credible. A credible offer should receive a credible counteroffer. And if that's the case, now we're off and running, and we've all started off on the good foot, and we can move forward. On the other hand, a credible offer might receive a competitive, or what some people call a stingy counter offer. And if that's the case, then the response to that should probably be a competitive and a stingy counter to that counter, so that you can let the other side know, look, this is just not appropriate. And we need to get back on the making credible offers and counter offers, and the mediator can help out with that. The next 3 bullet points, I'll just summarize and say that this is like greasing the wheel. In other words, if your negotiation is faltering somewhat, you're not moving toward one another quickly enough, there's still a huge gap and it's later in the afternoon, you might want to consider bracketed offers, linked moves. If you move, parties are at 100 and let's say 20, and so there's an offer on the table. If one party moves to 80, the other will move to 40. It can be suggested by a party or by the mediator, but those are interesting and can move things forward. I've got the bullet point talking about exploiting relative preferences. In other words, if there's something of value, something that the other side values more than your side does, you want to consider using that to provide to the other side so that you can get on your side what it is that you want. So you use that as a bargaining chip. The in-game adjustments to a reservation point, very important, because the reservation point that you determine pre-mediation more than likely is not a realistic reservation point for settlement as a result of your negotiations. So you're going to have to make adjustments to that. It's a tough thing to do, but that's the conversation that you need to have with your mediator, and certainly counsel with client. If you do get to this red zone, you're there, you're about to settle, but you're just not quite there yet. The question is, do I continue or not? And will I regret if I don't continue to negotiate, or do I just stand fast and have this impasse? And if I'm at the impasse, then I'm going to turn it over to my colleague, Mr. Bruce Ross, to talk about impasse breakers. But suffice it to say, there's a rule of thumb there, and it's my next to the last bullet point. The rule of thumb is that a settlement occurs after the first of two reasonable offers have been made. In other words, offer, counteroffer that are, quote, reasonable. Now that's the important point. But that the settlement occurs or will occur at the midpoint of those two reasonable offers. It's kind of a rule of thumb. Other than that, my last slide, basically, I just suggest and recommend that you use your mediator to your, what I'm calling your resolution advantage. In other words, confide in the mediator. Your mediator is going to help you, bring this thing home. If you confide enough in that mediator so that the mediator can help you help yourself get to that finish line. The mediator is the one person who's gone to every room and has got the temperature of every room and has read all the rooms. So that mediator's guidance is very important, and that mediator can bring it home to you. So use your mediator wisely and listen to your mediator carefully. And with that, I thank you, and I'll turn it over to Bruce Ross.
Thank you very much. Can everybody hear me?
Yes.
Yeah, we can hear you.
Okay, good. I apologize. One of the first problems that I should have dealt with at the beginning of this is to make sure that my computer would work. And for the first time ever, I've had major difficulties signing in. So if you see me on a phone, that's the reason. Let's turn now to what I've called closing the deal, or the mediator's proposal. We've gone through quite a few steps in the mediation, and now it's apparent that as much progress as we may have made, the parties are still far enough apart that there doesn't seem any reasonable chance that the case will resolve itself without some, let's call it arguably extraordinary action. And this is when I believe it's time to consider a mediator's proposal. There's nothing magical about this, and some mediators will never make a mediator's proposal. Others, like myself, will always have it in our back pocket for the very possibility that the case, despite several hours perhaps of negotiation and discussion and carrying of offers back and forth, has not resulted in a settlement. Essentially, as the name implies, this is a proposal from the mediator to the two parties. The most important aspect of this, in my opinion, is that it is done in a confidential way. That is to say, the mediator comes to a proposal, and I'll talk about how one might come to that proposal in a minute, and says, in the event of what we would call an impasse in the negotiations, says to all parties, look, we haven't made the progress that I was hoping we could make to this time in the mediation. The parties are exhausted or close to it. It's toward the end of the time that has been allotted for the mediation. I plan to make a proposal to each party. The major thing that you need to remember is, and I'll say this again when I make the formal proposal, is if each party has an opportunity to consider the proposal and advise the mediator in confidence whether or not it is acceptable. If, in fact, it is accepted by both parties or all the parties, if there are more than two parties, then we have, in effect, an agreement, and that can be broached with everyone present and the necessary settlement documents drawn up. And I'll speak to documents in a moment. On the other hand, if one party accepts and the other party rejects the proposal, the party or parties rejecting the proposal will never know what the other parties did with that proposal. So in effect, an acceptance can be made knowing a party who decides to accept the proposal can know that if the other side doesn't accept it, the other side will never know whether that party accepting it, in fact, also rejected it. The point of that, of course, is to maintain neutrality, confidentiality, and to let each party go their separate ways, and without having, in the case of the accepting party, told the other side, yeah, I was willing to accept that particular proposal. Now, I said, how and when is the subject broached? Well, as I mentioned, there are some mediators who will never declare or make a mediator's proposal, and there's certainly nothing wrong with that. I, on the other hand, and perhaps my colleagues on this panel, will, at appropriate times, make a mediator's proposal. And generally speaking, it's not one that's going to come early in the mediation. Rather, it's going to come very late in the process when we're looking at the possibility that the mediation will crater, which may in itself not be the end of the world. And it may be a reason why there's no point in making a mediator's proposal. On the other hand, if the parties have made enough progress that it appears that they're within reach of each other, if an extra effort is made by a neutral party, namely the mediator, each of them will, in consultation with their counsel, decide to accept the proposal, in which case you have a settlement. In the making of the mediator's proposal, there are certainly considerations for the mediator to think about. And in my opinion, a lot of this depends upon the mediator's particular style of mediation. I'm sure all of us have heard, and it's been written at great length, the quote unquote difference between evaluating a case and facilitating a case as a mediator, the facilitative model and the evaluative model. And of course, neither of these is mutually exclusive. And throughout a mediation, the process may turn from an evaluative approach to a facilitating approach. And in connection with the mediator's proposal, in my case, and I'm speaking only from my own experience as a mediator, I will evaluate the case. Because in most cases, I am being asked to mediate because of my background. I'm not a retired judge, and I also don't take mediations except in the estate trust and protective proceedings field and some professional responsibility and malpractice cases related to those fields. So in most cases, and this is being discussed, of course, in the pre-mediation conference, the parties who have elected to ask me to mediate are going to ask me my style, and I will say my style is both facilitative and evaluative, and I'm going to proceed in that way and work with you all in a cooperative manner to see whether or not we can resolve the dispute that has brought you here today. Now, that means, from my perspective, if I decide that at the end of the day, literally sometimes as well as figuratively, it's appropriate to make a mediator's proposal, I am not necessarily going to just split the difference between the two present offers on the table. For one reason, it may be that one of the offers is not reasonable. And it doesn't take into account all the factors that it's clear from the mediation should have been taken into consideration. So it's not just, in my mind, it's not just a question of splitting the baby and seeing whether or not we can get a deal. And at the same time, this is not something that I'm invested in. My job as a facilitator and evaluator is to help the parties resolve for themselves, with the assistance of their counsel, the dispute in question. I'm not judging it, obviously. And I obviously would like to see a settlement. I mean, several hours have been spent at a not inconsiderable expense. But at the end of the day, I go home, I've neither won nor lost. The question is whether or not there is a deal that has come from the process. Now, if we could turn to the next slide. This is a slide for which I'm grateful to Reva Getz, a retired judge, who many of you, I'm sure, know. With her permission, I've put her factors in dealing with impasse on this slide. There's also a reference to the Trust and Estates Quarterly, Volume 29, Issue 3. That issue from the California Lawyers Association is entirely devoted to mediation. So I encourage all of you who are interested in this field and involved in this field, whether as a negotiator, mediator, or counsel, to take a look at this article. There are lots of very helpful hints in this article, just as there have been in this presentation and the presentation that we heard last week with 3 other esteemed panelists for ADR services. I don't want to take the time to go through each and every one of these proposals, except to note that they deal with almost any kind of situation that would come up. One issue that I would like to deal with is the unreasonable lawyer. I'm not talking now about the unreasonable client. There are issues, obviously, to deal with that as well. But I'm talking about the unreasonable lawyer. And unfortunately, especially in this kind of litigation, oftentimes we have counsel that has not, based on what we've heard in the mediation process and in the documents that have been staged, has a reasonable position and is instead arguing for a position that ultimately is not likely to be sustained. In fact, may very likely lead to a loss on the part of the lawyer's client. What can be done in that case? Well, in my opinion, again, this is a personal view, but in my opinion, it is worthwhile taking the lawyer aside without the presence of the client and having a discussion with the lawyer, a frank and candid discussion about not just the strengths of the case, which you've heard about at some length, but also the weaknesses. Now, obviously, this should not be done without the consent of the client, nor, in my opinion, should it be done with the client there. Our interest is not in embarrassing the lawyer, obviously. Our interest is in trying to resolve whether or not we can facilitate a resolution of the case. And so I posit that as an option here. I also want to say, and perhaps I should have said this as a preface, each and every mediator is going to have her or his own personality, expertise, background, and the like in coming to or in being involved in the mediation at hand. And those issues were, I think, dealt with rather well a week ago by the other panel. But again, this is something that one needs to consider. Also, each of us is going to have a different approach and different ideas about how best to settle. I recall when I took my first lengthy mediation course about 40 years ago from a first-rate mediator, Jim Willamette, who's been a professor and involved with the mediation.com for many, many years. I asked him after one of the sessions, I said, what's your principal rule, if there is one, for a successful mediation? He said, do whatever works. So I've kept that in mind to this day. I've also borrowed, frankly, I guess stole is a better word, one of his approaches, a key approach, which is as a, and this is just part of my personality. I like to think of myself as Columbo. If those of you who are old enough to remember that show, Columbo would wander around, overcoat on in hand, and ask questions, go back and forth, and just sort of wander around, so to speak, in what ultimately would be, in his case, an investigation. In our case, would be the process of mediation. So for me, that has worked in the past. It's kind of what I've grown into. I'm not given to making pronouncements. However, since often I am being hired because of my background, folks want to know at some point, they want to hear some evaluative comments from me, and I'm more than willing to do that. And then it's just a question of where, when, and with whom, and in what context, and to what extent are both the lawyer and the client involved, or is there an opportunity to speak privately with the lawyer, again, with the client's consent. So I throw these ideas out for your consideration. I don't want to go further into in the interest of time into this, but I do recommend Judge Gett's article, and there's several other articles in there, including one that Judge Reiser and I wrote on Breslin. We don't have time, as Barbara noted, to deal with it in length. It could well deserve an hour's discussion, because in our view, Judge Reiser's in my view, there's some serious due process considerations with respect to a court order approving a settlement at which participants, a mediation at which all the participants were not present, and we hope represented by counsel. But again, this is a subject for another day. I just want to bring this up because it is an issue to be considered. And the thought, if you think about it, mediation itself, which is supposed to be a voluntary and assisted process, is that something that should be ordered by the judge? So we haven't heard the last of that. Finally, let's look very briefly at what I've called sealing the deal and written settlement agreements. Now, Judge Whitley has included an article or a PowerPoint presentation that he has done on this very subject. And I commend that to your consideration. It's quite thorough and goes into these issues in more detail than I can in the time remaining to me. But let's just look at a couple of things. Number one, of course, we have to have a written settlement agreement. That is a sine qua non. I've noted here an oral agreement reduced to writing within 3 days. If you look at the evidence code, you will see a section that says you can orally, if you think about this, an oral agreement reduced to writing doesn't really make a lot of sense, but it is in the code, and it says basically that you can tape record the agreement, and as long as it's reduced to writing within 3 days, you have a binding deal. I've never used it. I haven't heard from any of my colleagues in the mediation world that have used it. I think it's a dangerous proposition, because what happens if one party after the oral agreement, which is all there on tape recorder, within the 3 days says, no, I'm not going to sign it. So the evidence code section is there. I believe it's 1018, maybe 1118, but in any event, let's consider the importance of having a written settlement agreement, because otherwise everything that's been said and done in the mediation, including the discovery of documents prepared for the mediation, not otherwise discoverable, it's all confidential, and you can't, no party, including the mediator, of course, can share what information or deals or proposals were made. So the Fair versus Bakhtiari case that I've cited there makes it very clear that you must have a written settlement agreement, and the parties must waive the confidentiality provisions of the evidence code that otherwise apply in the context of a mediation. So that's a very important factor. Again, I refer you to Judge Whitley's presentation, the other presentation on that subject. Then Rael v. Davis, obviously, you have to have everybody who is a party to the mediation sign the mediation. No issue there, except in that case, of course, there was. They couldn't get one of the parties to agree, even though everybody apparently had agreed in principle, and the result was an unenforceable settlement agreement. Now, what about the so-called memorandum of understanding or term sheet, even a signed term sheet or a signed memorandum of understanding? And I don't know if I'm supposed to stop now or not, but in any event, we'll try to wrap up here very quickly. Again, if it's in writing and if it's signed by all the parties, then that may well be an enforceable settlement agreement. However, by definition, it's not going to have all the terms, and it makes very good sense to indicate what terms are missing. And if it's quote unquote boilerplate, that may be one thing. But if there are any material terms missing, I submit you should have a better memorandum of understanding. And then I suggest that you include a provision that gives the mediator the ability to mediate any disputes that arise after the fact with respect to ambiguities in the memorandum of understanding. And my final comment is, let's say you get to the end of the mediation and you don't have a settlement. All of us on this panel and last week's panel will always make ourselves available for additional input by phone or otherwise from the parties, and that's fine, and I support that notion. But bear in mind, it's important to distinguish between whether or not the mediation is continuing or whether or not it is terminated. Because if the mediation is continuing, then all of the confidentiality provisions of the code continue to apply. If the mediation has terminated, that is not the case. So we want to be very careful, I believe, in making sure the parties understand whether or not you are continuing the mediation, whether it's for further discussions by phone, or very possibly, and this is not a bad idea sometimes, to another day that may even been resolved in advance. I'm not a fan of mediations that have gone into the night. I don't think I don't think it's a fair way, a rational way to reach an agreement, even though I confess at one point I had a 2-day mediation which resolved itself in the 5 a.m. of the second day. I do not recommend that. I also recommend and suggest to myself that I better stop now, because Katie is ready to thank us for being on this panel. So I thank all of you, and I think we're happy to stay around if there are any questions that want to be directed to anyone or all of us. Thank you very much.
Thank you. You do see me popping on here because we are at the 1 o'clock marker. So I did want to note that if anybody has to head off and get back to work this afternoon, you will receive the full MCLE credit before you. But I believe our panelists have a few questions here. If you're willing to stick around for just a couple of minutes to respond to some of those. If anybody does have to head off, you will be directed to a brief survey. We would really appreciate if you take a couple of minutes to respond to that. Let us know how we did today, and especially let us know any ideas for future programs that you would be interested in, as we're always striving to offer things that you're actually interested in learning more about. So for a few of these questions, Judge Johnson, I see that you were answering some of them. Thank you for doing that while we were going through the other parts of the program. I did want to vamp a couple of those, especially, somebody asked what happens if opposing counsel doesn't want to share their brief. How can attorneys encourage them, or how can the mediator encourage them to share the briefs?
I'd be happy to take a
Focusing that on
first shot
someone
at
in
that.
particular.
I always ask for briefs. And by the way, I use the word brief in its lowercase sense. I do not need a lengthy document. I like to even say, I mean, I have no ability to sanction anybody, but I suggest that 15 pages is my limit. I discourage exhibits. On the other hand, if both parties want to submit an agreed list of exhibits, I'm okay with that. I don't want depositions. I might want a highlight or two, but I ask both sides, are you willing to share your briefs? And if one or both sides say, no, we're not going to share my brief, our briefs, then I'll talk about it. I'll suggest that it's going to be helpful because we're trying to resolve this case, and this is the kind of thing that you're going to hear and your opposing counsel is going to hear at trial. But if that's unsuccessful, then I regard my obligation to be not to share the briefs, even though I strongly urge the attorneys to do so. The other thing I will say, and whether or not that issue is on the table, is if you have something that you believe for your reasons should not be shared with the other side, then why don't you just put that in a separate document and let me know that that is not to be shared. That also means, of course, that when you are preparing your brief, don't just say confidential brief, because by definition, they're all confidential. We're in a mediation. Say confidential, and then have either indicate to the mediator or say it in the brief, if you both have decided to share it, may be shared with the other side. And conversely, if you're giving something to the mediator either before the mediation, well, let's say before the mediation, indicate this is not something I want shared with the other side. And then, the mediation can proceed on that basis.
In that context, one of the handouts is a questionnaire that I send out for every mediation, and that questionnaire is a requests confidential answers to 10 questions that I include. And those come back to me. I also give counsel the option of also submitting a brief or a mediation document. I don't require, I'm much more relaxed in that. I don't require that they share. I just suggest or recommend. And so if they don't want to share, I deal with it at the mediation. I don't find that it has been a problem. Some lawyers that I have mediations with tend not to want to share, particularly when there are certain other lawyers on the other side. And I'm pretty okay with that. We deal with it at the mediation. Oftentimes, once we get into the mediation, if it seems like it's relevant, we can get them to share all or a portion if they haven't done it before. But it's that questionnaire that I really find to be very helpful. And it's helpful also because it actually helps tease out some of these expectations or issues that the lawyer may have with respect to the client, or even the mediation session itself that may not be included otherwise in a brief. There's a couple of other questions here that are really interesting questions. For instance, do you ever share or explain to a party the reasons for a mediator's proposal? And I'd be interested to hear what everyone else says, but I try to include in my proposal, which is usually in writing. Some I do, verbally, right off the cuff, but most of the time I do them in writing. And I try to include a blurb as to what I have considered. It does get a little, I'm as specific as I believe I should be in that, but sometimes I'll even say something like including some subjective calculation that I won't, confidential subjective calculation that I've made. I'll include some language like that. But so I think I'd be interested to hear whether, there's any, whether other panelists include any more explanation relative to their mediator's proposal.
Speaking for myself, I will put the proposal in writing, but I will normally not give any reasons. What I might do, however, is independently and confidentially give each party some reasoning, which of course is not being shared with the other party. But the mediator's proposal itself, I agree it makes sense, especially in any complex case, to have something in writing and to say, this is my proposal, A, B, C, D, and repeat the fact that the acceptance is not conveyed to the other side unless both sides or all sides agree.
I don't have anything to add to those suggestions.
Related to the mediator's proposal issue you were discussing, somebody asked, if one party accepts the proposal and the other doesn't, they find out there's no settlement, then it's quite obvious to the accepting party that the other side didn't accept. I guess the underlying question is, like, where do they go from there, knowing that information?
That's a good question. I mean, the importance of the other side not knowing is that the side that has accepted it realizes that this is not, at least for now, gonna close this deal. But no confidence has been exchanged because the other side doesn't know what the accepting party has done. I think that's the protection for the party, and then the I guess the litigation proceeds unless at some point they want to reconvene a mediation, but they haven't been. The accepting party has not been prejudiced by the fact that the other party didn't accept it. And by the way, I'd be very interested to hear from our colleagues on the panel. Most of the time when almost all the time, I don't want to say every time because frankly, I don't keep a score sheet, but almost all the time, my mediator's proposals have been accepted. I remember one in particular, there were 5 different parties. Nobody seemed to be able to agree about anything. And yet I made a mediator's proposal to all 5 parties, and it took a while, and there were some additional calls, but it was accepted by all the parties. So I think any of us who are making a mediator's proposal are doing it based on our experience and our good faith belief that this may be the answer to resolving what has become an impasse in the mediation process. And I go back to, in terms of looking at my own approach, is I've been asked by these folks to see whether or not I can help them come to a deal and move beyond the litigation process. So as part of my toolbox, I think mediator's proposal usually makes some good sense.
Yeah, I think mediators' proposals are mostly accepted. I will say that, and my colleagues probably agree with this. I don't do them unless all the parties agree that they want me to do them. Also, you can generally tell when a mediator's proposal is appropriate. And if you're asked to do a mediator's proposal, and I've been asked to do a mediator's proposal, when it just didn't seem to be appropriate and it was just the wrong thing to do, I might have resisted that and continued the negotiations or suggested something else, and we've gotten to the settlement through some other means. This idea about anyway, I'll just go ahead. Barbara, you wanted to say something?
I just think by the time we get to the mediator's proposal, as you said, we generally have an idea of where the parties want to go, but either they can't say it in front of their client, or their client is resistant, or they don't want to feel that they are the ones that are relenting. And so most of the time that I've done them, they've made suggestions. I mean, I've had one person, I don't want to hear a mediator's proposal that goes under $70,000. Well, that's not how you do.
Right.
That's not how I'm going to accept it. I'm going to tell you what my experience is. And so most of the time when you make a mediator's proposal, it's based on where you have a feeling of where everybody really wants to be. Nobody's going to win or lose. And I do say in a line or two why I'm saying this. This is what I think the facts are, and this is why I'm giving this proposal, accept it or not.
And I agree with Judge Whitley's suggestion that you want the parties to be in agreement. I put the issue, though, to them in a way which strongly supports my interest in getting an affirmative answer from both sides. And I wouldn't be doing it, frankly, until the appropriate time. And I agree with the other panelists that timing is, like it is in a lot of things, is everything here. There's one other thing we didn't touch on. I don't recall if it was mentioned at last week's proposal, but there's also the approach, if you will, of going privately after some discussion to each party and saying, if I could get you to this number, may I push that same number on the other side? That's a bit controversial, frankly. Is the mediator putting too much of her personality into the mediation? On the other hand, many of you will recall with fondness, I think, and great respect, Judge Gold. His very common practice was essentially evaluative, and at many occasions he would do just that.
Yeah, I don't have a problem with that. I think it's actually a good approach, and I don't think it's interjecting too much. I think what you're trying to, it's certainly nothing unfair. I mean, parties still can make their own decisions. So I think it's always a good idea to keep that in mind, that you can, which is I think a way to sometimes, break a stalemate. And that's one of those things that you want to potentially use to break a stalemate. For instance, like there's a question about baseball mediation up here too. And I don't know what the questioner has in mind in that regard, other than what I was trained with in terms of baseball is where each party writes a final confidential, each party writes a final confidential offer and gives it to the neutral, the mediator. The mediator selects one or the other, and the parties could agree that that is a binding, decision on the part of the mediator. That's what I understand to be baseball mediation. I have used it one time early on, years ago in a mediation, because the parties were willing to do that. There's also golf. I won't get into that one right now, but there's also golf as a icebreaker, and a few other things like as icebreakers that we as mediators know that we can't let you know about.
And I've never used baseball. In theory, I suppose if both parties want to do it, there's no objection to doing it. But you're turning the mediator into that case into an arbitrator, in my opinion. It's no longer an assistive, facilitative, or evaluative voluntary process. And as for golf, if I had a golf mediation, I'd be putting the ball so far into the rough that it would be useless to even try.
Yeah, I think these are kind of desperate things. And frankly, the one that I did use, they were so close that no one wanted to blink. And they just needed a third party to push them in.
I do want to jump in here in the in consideration of time. We have kept folks almost 20 minutes extra, so I do want to let everybody go this afternoon. But I really appreciate all of you sticking around to answer some of these questions. And again, anybody, if you have additional questions, our panelists were kind enough to put their email addresses into the materials. You're welcome to reach out to them or to their case administration teams if you're interested in setting up a case or anything.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.